All right, greetings, everybody. Thanks for joining us. My name is Eric Hauge, and I'm the Executive Director at Homeline. And you're joining us today on December 8th at 1:30 for another one of Homeline's webinars on tenant landlord law, specifically focused on today on COVID-19. The end of the COVID-19 eviction moratorium and what's going on with evictions and other aspects of tenant landlord law throughout the state. Just a few brief overview slides, and then we'll get on with today's session. Joining me today is also Rachel Sterling, Homeline's COVID-19 Eviction Response Coordinator and Housing Attorney. And we're excited today to have a panel of legal aid attorneys from throughout the state to share about their experiences, what they're seeing in their communities throughout the state of Minnesota in housing and eviction court. Before we get to that, though, we'll do a few logistical things, and Rachel's going to, again, like we do at the beginning of all of our seminars, do a very brief overview about the current situation of the current state of the law. So just a reminder about what Homeline is. We're a statewide nonprofit. We provide free legal advice and information to any renter throughout the state. And we have staff that speak English, Spanish, Somali, and Hmong languages. There's our tenant hotline contact information. You can also email us directly on our website. So today and in our previous webinars, we do provide general legal information, practical advice, and information about current tenant landlord law. But we do ask renters, if you have a specific question about your situation, give us a call. On our website, and I'll throw these links in the chat in just a minute, are some materials, information for renters and service providers and folks that might have questions about the current situation with the eviction phase-out law and related issues. Here's our upcoming schedule. Today's session, again, our panel of legal aid attorneys. And then we have one scheduled in January where we'll be we'll have on several state legislators to talk about some priorities in next year's legislative session around tenant landlord law. And we are tentatively working on scheduling another session in late January or early February on the recent ballot measures in Minneapolis-St. Paul on rent control and the impacts of those passing and kind of next steps on those. So we'll have more information once that's scheduled sometime in late January or early February. I'll throw links in the chat on all those. Again, Rachel's going to go over a few slides on the current situation, and then we're going to have our panel. We did get some questions submitted in advance, which we will get to after our panel does some opening discussion. But if you do have any questions throughout the session for the panel, please use the Q&A system over Zoom to submit your questions so we can keep track of them there. Thanks for joining us, and I'll hand it over to Rachel.
Thank you so much, Eric. I appreciate that. So yeah, like I said, like Eric said, just a very quick overview of where we're at right now, what's happening with evictions. Basically, since October 12th, there hasn't been any change in what phase we are in. If you've been participating or viewing these webinars previously, you will know that we kind of broke everything down into the different phases of when different things were happening. So on October 12th of this year, we basically went back to pre-pandemic rules with one notable exception that I'll get to in a minute. But that means that evictions can be filed, and for most legal reasons, and even if the eviction doesn't seem to be of something that is accurate, or if it is for a reason that's not allowed still, as a tenant, this is just something that we need to get out into the world, is that if an eviction is filed, the tenant has to show up to whatever virtual Zoom court hearing is scheduled for the eviction hearing, whether you have a pending application, whether you think that the landlord is correct in what their complaint is stating. Just show up, because otherwise what will happen is that a default judgment is going to be filed against you. And that just means that you won't be able to have a say in anything that's going on, and basically means that a writ will be issued. So I talked about the exception in place still is if you are behind on rent and you have a pending rent help MN application or one of the other COVID-19 emergency rental assistance programs, an application with one of those, you cannot be evicted for non-payment of rent. That protection is going to be in place for a little while yet. So again, if you are behind on rent, you should apply for Rent Help MN. That's the big program that's still open and available at this point. There were others in the past, but they've kind of closed down their application process since as they are coming to the end of their funding. My understanding is Rent Help MN still has plenty of funds, so they'll be open for a while yet. But again, that is the only way, that's the only lingering protection that still exists for tenants, and that's only for non-payment of rent evictions. So if we go to the next slide, Eric, this is kind of, again, just more reiterating that this protection lasts until June 1st of 2022. So there's another little over 6 months left of this protection in place. The tenant has to give proof of that application if they have it, either to the court or to the landlord. That's in their best interest to do so as soon as they apply, just so that there isn't any confusion come the court hearing date if there is an eviction filed, because frankly, a court is just not going to know if a tenant has an application or not unless the tenant tells them. So it's best to apply, show that proof of application right away. And then, if there has been an eviction filed, even if there was an eviction filed before you applied for Rent Help MN, you should still show up to the court hearing, show your proof of application, that you have a pending application, and work on getting that all sorted out with your landlord if you are a tenant. And then a couple of other things just to quick talk about, just for clarification's sake. So on the next slide, we're going to talk about lease terminations and non-renewals. A notice of non-renewal or lease termination that was given before October 12th of this year wasn't valid unless it complied with one of the exceptions that was listed in that phase out. After October 12th, the lease terminations and non-renewals still needed to comply with whatever notice requirement was given either in the lease or by Minnesota statute, but you didn't necessarily need to meet one of the exceptions that was listed in the phase out, just needed to be for a legal reason. And then there's no more pre-eviction notice requirement as well. That was something that was part of the phase out, but that's no longer required. In the next few slides, I'll go through quick the cities that have given pre-filing notice requirements, as well as some federal level ones. So in Minnesota, St. Louis Park and Minneapolis both have pre-eviction notice requirements. So in St. Louis Park, at least 7 days before bringing an eviction action for non-payment of rent, a landlord needs to give a notice, a written notice that they're going to be doing so. And in Minneapolis, it has to be 14 days before bringing an eviction action for non-payment of rent. You have to give a written notice. So those are the two Minnesota city level ones. So if you reside in one of those cities, this is our requirements that are new this year. And then another level of notice requirement is actually a lingering, all right, well, first we'll go through HUD quick on the next slide. HUD actually just passed this recently, a month ago today, actually. Basically, it's kind of in tandem with what was required under the CARES Act. But basically HUD housing providers need to give a 30-day notice to public housing and project-based rental assistance tenants prior to any eviction for non-payment of rent. the thing that's different from the CARES Act is that it has to include information about what local emergency rental assistance programs are available. And it only applies during national emergencies, such as the COVID-19 pandemic. So this is in place right now. It's effective right now. So if you're a tenant in one of these properties, you have to be given a 30-day notice before an eviction action could be filed. And then finally, and I keep referencing it, the CARES Act, for the most part, expired back in July of 2020, but there is a lingering 30-day notice requirement for CARES Act covered rentals, which are most of the rentals that have some kind of federal subsidy, basically anything that's covered under VAWA, or anything that's got a federally backed mortgage. So that's Fannie Mae, Freddie Mac. This is a little bit harder to figure out. If you are in a CARES Act covered property, there are websites that give that information, that help you try and figure out that information, whether you're a landlord or a tenant. So I'm not going to delve too deeply more into that. We've heard this song and dance before. So, but that is kind of my really quick overview of what the current law is. There's still one protection in place for tenants who have pending applications with a COVID-19 emergency assistance program. So if you are behind on rent, you should apply at Rent Help MN. Okay, I think that is my piece. So let us get into the panel discussion. So with me today, I'm going to go in order that I see you on we'll go in the order of the slide. Never mind. So first off, I have Katie Pock, who is a staff attorney at the LSNM group. I'm going to try desperately to remember all of the letters for all of the acronyms for all of you. There's a lot of them around, but it's the Legal Services of Northwest Minnesota. And then we also have Chris Macy, who works for the Legal Aid Society of Northeastern Minnesota, right? So kind of separate, but sort of similar areas of the state. Brian Lipford works for the Southern Minnesota Regional Legal Services as a staff attorney down in Rochester, Minnesota. And then Luke Grunman is with Mid-Minnesota Legal Aid and as a managing attorney here in Minneapolis. So again, thank you all so much for joining us. I did have just a couple of set questions that I gave before earlier this week to the panelists to kind of get a heads up on what I was going to be pestering them with. But again, if you have questions that come up during this, please feel free to put them in the Q&A and we'll put them to our panelists, whether they are for the individual or as a group regarding. So all of you work in housing in some way, shape, or form across the state, which is why we wanted to bring you together. So my first question to you is going to be, can you please introduce yourself? Tell us what region of the state you work for. And first off, the kind of just something, if there's anything interesting about what your group does, what your organization is, just a brief overview of all that. So let's start with Chris, since you're first on my video line.
Yeah, sure. Can you guys hear me?
I can hear you great. Thank you.
Okay. Yeah, my name is Chris Macy. I've been at Laszdom Legal Aid Services of Northeast Minnesota for 5 years. And our headquarters is in Duluth with satellite offices in Grand Rapids, Brainerd, Virginia, and in Pine City. There's just one attorney in Pine City. I'm in the Brainerd office, and the other attorney in my office recently moved. So I'm the only attorney in the Brainerd office with one paralegal and one legal assistant, and we cover Crow Wing County, Aiken County, and half of Cass County. And there's a lot of poverty in these rural areas. And given the nature of our resources, the attorneys, we do everything. We're not siloed whatsoever for the most part. I think maybe in Duluth they have one housing attorney, but otherwise we do housing, public housing, lots of family law and domestic violence, government benefits, consumer debt, any civil legal issue really. But housing, of course, has been a priority as always. we actually had a kind of rudimentary eviction court we set up before COVID hit, which really was just an attorney and a paralegal posting up at the courthouse, and we'd get the complaints in advance so we could issue spot. And then from there, we'd negotiate with landlords, meet with potential clients. It was very fast paced, but it was very effective. The judges loved it because they'd have less trials. And if there were trials, they'd be more efficient. And what's happening in our area now is similar, except it's over Zoom. I guess I'll leave it at that for now.
That was great. Thank you. All right, let's go. Let's see. Next in my video line is Brian. Would you mind giving us a little bit about yourself and your organization?
Sure. So I work for Smirls. We cover the southern half of the state. I work in our southeast region, which is 11 counties in the southeast corner. And we have offices in Winona, Albert Lee, and Rochester. So we have a mix. Rochester is, most of it's rural counties, but Olmsted's a little different because the city of Rochester. We have a joint eviction clinic that we run with Legal Assistance Olmsted County. We've been doing that since before the pandemic. We started that in 2019, similar to what Chris was outlining. And currently we have kind of a consolidated clinic that four rural counties have joined together into a single docket. So that's been operating during the pandemic. And so that's kind of what we do in our neck of the woods.
Awesome. Thank you. All right. Next, I've got Luke.
Hi, all. Thanks for having me. Luke Grunman. I'm with Mid-Minnesota Legal Aid. Our office covers approximately the middle third of the state. We have offices in Minneapolis, St. Cloud, and Wilmer. I'm mostly familiar with our work in Minneapolis and Hennepin County Court. And let's see, I've been doing landlord tenant for 6 years now, and done some other things before that, and got some wonderful colleagues. I'd say the most interesting thing that we've had in place really since the beginning of the pandemic in Hennepin County is that every family who appears in court and asks for a lawyer, every tenant family gets one. And we thought that wouldn't be able to continue once the moratorium lifted and we got the increasing levels of cases that we have now. But thanks to the involvement of Hennepin County, which has put its own staff attorneys into the effort, we've been able to keep doing that. So that, I think, is the most interesting thing. It's definitely really affected the practice. We have, I think, 85 cases a week starting next week, or that's what it's about at in Hennepin County. And that's a lot of cases. The court has stretched to accommodate having families actually get representation in all those cases. It's a pretty cool thing to see. It's also causing a lot of growing pains at the court and elsewhere. So, but it is an interesting practice. Thank you for having me.
Thank you, Luke. Yeah, we'll get a little bit deeper into some of the court stuff just in a little bit here. But Katie, last but certainly not least, would you mind introducing yourself?
My name is Katie Pock. I'm a staff attorney with Legal Services of Northwest Minnesota. We cover 22 counties in Northwest Minnesota. We have 3 offices, one in Moorhead, one in Bemidji, and one in Alexandria. I'm in our Alexandria office, so I'm primarily practicing in 7 counties right around the Alexandria area. Prior to the eviction moratorium ending, we actually didn't have any organized housing courts in our area. We practice in a very rural area, so that's definitely been an adjustment. Now that the courts are doing a little bit more of an organized housing court, so that's been an adjustment. But we're also in a rural area like Laszdom, so we practice everything. I do housing law, family law, pretty much any civil legal issue. So
awesome. Thank you so much, all. Okay, now we're going to, I had given the panelists kind of 2 questions ahead of time. And so now I'm going to ask the first one. Some of you have kind of touched on this, but I would like to hear from everybody with just how are courts handling evictions in your area? Kind of like what's going on, what's changed? This is especially relevant now that we're talking about how the restrictions on what could be evictions could be filed are essentially lifted, except for that one exception. So what are courts doing around the state, especially in your area, and how is this impacting what you do? Do you want to go in reverse order?
Sure. I'll talk about our area. So our office covers parts of 3 different judicial districts. And like I said, we're a very rural area. And they anticipated a backlog of eviction cases in our area, but because we're so rural, they didn't think each county would have enough evictions to really do like a calendar in each county. So what happened was court administration got together in all of our judicial districts, and they've been doing housing court as a judicial district. So the 8th Judicial District has a housing court twice a week. The 7th Judicial District actually split up into 2 halves and has housing court. And then the 9th Judicial District has been doing housing court as a whole. What that has meant for us is that we've been partnering with MMLA actually, because they share the 8th with us, and Laszdom because they share the 9th with us. And we've been doing housing court that way. This was new because before the pandemic, obviously we just had, hearings here and there in counties. So it's been a learning curve, but it has gone really well. We've had great feedback from judges who that were there to talk to tenants right on the spot. I think we've helped settle a lot of cases and, helped represent tenants. And so I think it's been a really good thing. The problem is now that evictions are slowing down, the 8th and 7th Judicial District have stopped doing district-wide calendars in our area because they didn't have enough cases to sustain it. We have got some lasting change though there. We have talked to some of our bigger counties, Clay County, who has Moorhead, and Otter Tail County that has Fergus Falls, do more of a dedicated calendar so that we can appear at those cases. So we are working on getting that in certain counties. And the 9th Judicial District is still doing a dedicated housing court calendar for evictions, which again, I think has really helped with the efficiency of the courts. So that's kind of what's going on in our area. We have seen a lot of evictions, but I don't think it was quite as many as we anticipated with the backlog. We were busy for a few weeks, but like I said, the 8th kind of has slowed down. There's hardly any evictions in the 8th now. There's still quite a few in the 9th, but we're getting through that backlog as well. So that's what's going on in our area.
Okay, thank you. Luke, you touched a little bit about some of the changes. I know Hennepin has a lot, so this, if you want to give highlights, because otherwise we might be here for another 2 hours.
Sure, that makes sense, Rachel. No, yeah. Well, okay, so just highlights. Pre-pandemic, we had bigger calendars of like 45 cases a calendar, and those are 3 days a week. So now there's 20 case calendars to fit into a 3-hour block. And so then those to get to the numbers that we have now, which like I said, have been ebbing and flowing a little bit, but are right around 80, 90 cases a week. There have to be these 20 calendar blocks sort of throughout the week. And those, run, I'd say fairly efficiently, some days more than others. Default rate is way too high. But that unfortunately affects the efficiency of the calendar. And everybody shows up and everybody wants a lawyer, then we're pushing the 3 hours to get. And then there's very little room in that context for a lot of actual litigation. The courts are pretty liberal about setting them on for trials, and then motions to dismiss are oftentimes argued at the beginning of trial. Sometimes with briefing in between, but we'll get discovery orders. Trials are getting scheduled further and further out as cases are more contested and backed up. We're trial calendars into January at this point, and then decisions are taking a long time from the referees. In a lot of cases, we're waiting 60 to 90 days to get decisions on eviction trials. But I think that dynamic has done a lot toward changing landlord behavior and landlord council behavior. They've just realized they can't press the eviction button and get what they want very easily. So I'm hopeful that will have an effect on just the number of filings. That is part of what's keeping the filing rate down. Is that the right to counsel approach is changing the mentality of landlords.
Thank you for that. I applaud your brevity. Brian, I think you're next in my list.
Sure. So in our region, we're getting, I'd say, 25 to 30 evictions a week is what we've been seeing. And following up on what Katie pointed, we also worked with court admin to set up this consolidated calendar. It's all from the 3rd Judicial District, but there's 4 counties that on their own, fairly rural, wouldn't have been able to have supported a clinic, have now consolidated one. And that's one of the great opportunities in Zoom is you can have one judge and 4 tenants from 4 different counties showing up and we're there. So I think that's been a real success. My hope is that might have some carryover because it really has expanded our footprint and allowed us to help much more people than we would have been able to with a housing unit of 3 attorneys and a paralegal. We couldn't be in 4 different counties, or if we did, it'd be incredibly inefficient to try to help those folks. So, and we're also running a model. Sounds like what Luke was outlining, that if you show up and you want an attorney, we're able to help you.
Awesome. All right, and Chris.
Yeah, a lot of what Katie said is applicable to our practice area as well in the Northeast. It's a little different because everything's over Zoom. The 9th district which is where I am, right in the middle of the state. Our hearings are almost all they have a very consolidated calendar. I think it's almost all on Wednesday. Trials are a little bit more scattered, but even then they try to do the trials all on Wednesday. The Duluth office in the 6th district, they have their initial hearings on Monday and Friday with trials on Wednesday. So it's still pretty centralized. And I know they've been talking about decentralizing it, which we're against, because it's nice having it all centralized. We can show up. We know ahead of time how many evictions there are. We get the complaints ahead of time, so we can kind of issue spot. And then we also know how many evictions there are going to be, so we know how we have to staff it. It's a big cattle call over Zoom. And Katie said it often overlaps. I've seen Katie in there before from the Northwest. And the other part is to have noticed that we have referees here that do the evictions, and they've over time gotten more experienced doing it. The judges up here, they do everything. And so a lot of times as legal aid attorneys, we're the experts in the room. So we have to kind of educate the bench. And that has been seems to be not the case as much anymore, which is nice. And the judges, we've got very good feedback from court administration and the bench, which is always nice. It's gone surprisingly well. I think people were so worried that they over-prepared. And so it's still a little hectic at times, but it's gone pretty well. Anybody who qualifies for us, judges, referees, give them a chance to give us a breakout room and talk. So we provide a lot of legal advice and full representation to a lot of people. A lot of times you can get them dismissed up front, but usually you set it on for trial and hopefully you can settle it or let the judge decide.
So that kind of actually leads me nicely into my second question. So thank you for that segue. So how have cases or issues that you're seeing changed since October 12th? I had mentioned earlier that was when the most of the protections lifted and evictions for a great majority of them could proceed as quote unquote normal. So what have you seen changed since then? I'm going to do this in a slightly different order. Brian. Let's put you in the hot seat first.
Sure. So I guess what we've seen recently is a fair amount of mobile home related evictions. That seems to have been an uptick. I don't know if that's a trend elsewhere, but we've certainly seen that in our region. We're also encountering, although it's probably hard for us to see since all of us are so familiar, but we've seen a fair number of tenants that have never heard of rent help before. And then they're coming in on payment of rent cases, have never heard of it, don't know how to apply. Sometimes they're there at the courthouse because they don't have internet. And so we're seeing a fair number of those as well. Additionally, anecdotal, but we're seeing a fair number of occasional cases that will have been filed, but then the landlord will have taken it off the calendar saying that they've applied for rent help. So because we get the lists ahead of time, a lot of times they'll have been on the docket and been canceled. So we are seeing some of those. And I guess an increase of straight non-renewals by landlords deciding that they no longer want to rent to someone.
Okay. Luke, what sort of cases have you been seeing? Have they changed at all since the 12th?
Yeah, right away there were a few more holdover cases, but since those were all filed on the basis of notices that had been given prior to the effective date of those being allowed, then those were mostly thrown out. So I'd say I think the holdover work has picked up in December now, since some of the more legitimate notices gave a November 30th move out date. And so now it seems like we're starting to see Rachel, I'm sorry, when you outlined all the notice requirements for non-payment cases now, I mean, the practice has really become like which sets of notice requirements may apply, especially with our local ordinances and everything. And so there's still a number of legal defenses to those notice cases, non-renewal notice to quit cases. There's a lot of retaliation stuff going on, some discrimination cases that we've had on those holdover cases. But I'd say one significant difference in the last couple of weeks is we've had to litigate those holdover cases a little more straight up, like on the merits, rather than just saying this is defective notice, get it out of court. We definitely have some more that have been set for trial and deal with some of those more substantive issues.
So you're having the fun time of having a fun dealing with the eviction cases that also have like pandemic issues with them, along with also these new notice requirements that are also fresh for the court as well. So you kind of have a double hitter of new law to wade through.
Absolutely. But I will say, and I don't even know if any of them are on, but the Hennepin County bench has really done a good job, and they've even taken it upon themselves in some cases to really drill into, like, these notice requirements are not just there for the heck of it. We have these here for a reason. These are intended to give people information about their cases. And so they've all three of the referees in Hennepin County have been really good about requiring that those strict requirements be there. And so they'll walk through the Minneapolis ordinance, for example, and make sure that each element of what the ordinance requires is actually present. So it's so yes, we are learning, we are having to learn and adjust, but it definitely helps when we have a bench who's pretty with it. So
yeah, I said it before on a couple of different places, but it's very odd. It's kind of interesting, a little exhilarating to be in an area of law that is just about constantly changing at this point. That's not normal for laws, as everyone else knows. It takes months, years, decades even to change any change in a law. So the fact that it, for the past year or so, it's been changing on a month-to-month basis is different, certainly. One thing I wanted to mention, because Luke was using some terms that I just want to make sure that folks had a general understanding. When we use the term holdover, what that just means is if a notice to vacate for the end of a lease term or something happens and then passes and a tenant is still in the property, they're considered what's called a holdover tenant. And then a landlord would file what's called a holdover eviction to have the legal process of removing a tenant from the property. So I just want to make sure we have a ground basis for what that term means, since we tend to bandy it about a bit. And that's going to be like some folks were saying, starting in December. That's kind of I know Homeline's been tracking eviction cases throughout the state for the last couple months, and we're definitely seeing an uptick in holdover complaints when we're looking through those evictions. So, okay, Katie, do you want to?
Yeah. So since October 12th, I think most of the cases we've seen have been non-payment. And we have actually had quite a few people who have not known what rent help is when they come to court, which was a little surprising to me, since, you know, I'm in the loop, so I see rent help everywhere. But that's been one of our big challenges. More recently, since December started, we've seen some just termination notices. But it has been really hard for tenants to find housing. And so I think we're going to get a lot more of holding over, because out in rural Minnesota, we've always had a lack of affordable housing, but particularly landlords now are a little wary of renting to people because they haven't been able to evict for so long. So we are really seeing people having a hard time being housed and having a hard time moving. So I think that those are going to be litigated a lot more coming up as well. The other thing that's really changed since October 11th is not really with the eviction filings, but just with courts out here. As Chris mentioned, we're in a very rural area, so our judges do a little bit of everything. And during normal times, they hardly ever saw eviction cases. You know, they might see one or two a month. But since our eviction court started, judges and referees have become a lot more familiar with eviction cases, which I think has been helpful to everyone. It's become more efficient for the court, and it's a lot of times better for tenants, because now courts know what proper service looks like, and they're not going to hear cases that don't have proper service and procedural issues like that. So that has been a change since housing courts have started in October, which I think has been very good.
I know you said that some of the counties have done away with their housing court stuff, but do you think in some of them it would be something that they'll bring back again, or, you know, at least the kind of consolidated, because it sounds like the judges are really appreciating that kind of focus.
We're hoping so, and we're working on it. The 8th district, the site of the 8th district that we're in is very rural. And so since they stopped housing court, there have only been about 3 evictions on our side of houses. So they might not bring it back. But in the 7th district, which is a little more populated, we're working with some of the bigger counties to say, even if they don't do whole district-wide housing court, if specific counties, especially counties that have a lot of evictions every month, will do a housing court, then we can show up, and it makes it a lot easier, because we've been trying to show up anyway, but when you have 22 counties all doing housing at different times, it gets really hard to show up. It's not very efficient use of our time. So we are working, and we have gotten really good feedback from Clay County, who's agreed to do a housing court calendar starting in January. And we're also talking to a couple of our other big counties. So we're hopeful.
Awesome. Well, Chris, what have you seen? I know that it's not probably a lot of what you're seeing is the same as what everyone else is seeing, but if you have anything to add, or that'd be great.
Well, yeah, after October 12th, there was an initial uptick, certainly. But the other thing is the rent help money started coming in, and landlords generally just want to get paid. And so once that money came in, it helped a lot, because over 90% of evictions are unpaid rent. And otherwise, I'll just reiterate that the court administration and the legal aid upper echelons and the bench have been coordinating so well. And since it's just gotten a little better, it seems like, as it goes
Nice.
on.
Are you also seeing tenants who come in who just have never heard of any of the assistance programs that were put in place for this COVID stuff? Or
Not too often, but
Okay.
sometimes. But you know, sometimes still we get a landlord who just they want to evict for unpaid rent, even though the person had applied for rent help. So you just dismiss it, and they're not happy about it. But that happens surprisingly more often than you'd think. But.
Oh, yeah. Okay. All right. Well, I know I'm going to turn it over. I think we are open for some questions. But Eric, I think you had a question as well you wanted to ask the panelists.
Yeah. Yeah, thank you. This has been very informative. It's great to hear what's going on in different parts of the state. So thanks for sharing. I know that from week to week we've had, well, we're only doing these like once a month now, but we've had a lot of social service providers that join these calls and that are working with clients, tenants that might be facing housing instability or actually having an eviction filed against them or a notice to vacate, non-renewal, et cetera. So, and you know, you've shared a little bit already, but I'm wondering, and I won't go in any order if anybody wants to just jump in and answer this. If you have any specific advice that any of you might have for tenants or particularly service providers who are working with tenants who are either facing an eviction filing or have been given a notice to vacate or non-renewal, any sort of both legal advice or practical advice about what a service provider can do to help in those types of situations. I mean, I can start calling on people, but.
Well, I'll just say that, you know, sometimes there might be no defenses and you have to leave. And if that's the case, I would just say, consider somehow working in an expungement if there's an eviction filed to it, because that can help long-term. I'm just saying, if there's no defenses, they don't have the money, they have to leave, an eviction is filed, maybe ask for a little bit of extra time and say, if I'm out on such and such date and the place is clean, you'll agree to expunge it. Some lands wanted to take it, and that way at least they get the eviction wiped off their record. I've used that before sometimes with almost like a win-win kind of situation. I don't know, it just popped into my head.
Yeah, I would encourage tenants to try and get legal help, at least some legal advice. So if they can call their legal services agencies if they qualify, because there might be defenses, and knowing it ahead of time versus showing up the day of court is always helpful. I mean, we will show up the day of court and try and help too, but knowing ahead of time is helpful. And if there are no defenses, you know, a move out agreement is always a great idea. I mean, like Chris said, trying to get it expunged. And if you have a move out agreement, a lot of times you can, you know, make sure either an eviction isn't filed, or if it is, that it's expunged as long as you're out by a certain date. Although I know right now people are having a really hard time finding housing, and I don't really know what you can do about that. I don't really have a lot of advice on.
I'll add a couple points in addition to all the absolutely spot on things from Katie and Chris, but two quick things come to mind. Is one, service providers can do a ton of good in like keeping their eyes and ears open to help us, or to help that family with their eviction case. You know, I mean, the service provider sometimes has evidence that the tenants themselves don't, because they are working with multiple families who are all living in that same building or renting from that same landlord. And what that can do is help show patterns, practices, discrimination, systemized retaliation, you know, and service providers have done a lot to getting that information out there in a place where we can really help folks if we get it. So I just say that is something that, you know, you don't need to be a lawyer to keep an eye out for that kind of thing. Just like have your radar up and be saying, this feels wrong. It seems like a whole bunch of folks are getting told to leave when they didn't do anything wrong except maybe stand up for themselves, or, you know, or this landlord changed ownership and the new owners just don't seem to like certain groups of people, or, you know, stuff like that. It's service providers can sometimes be in the best spot to see that. So
I guess I don't have much to add to the excellent comments that others, other than if you're a service provider and you're going to be referring someone to rent help or telling the tenant to apply for rent help, just make sure that that person has a good contact number. We've started to see some of these applications where they have a pending application and they're not able to submit all the documents or don't do that, and rent help can't get in contact with them. And then what eventually will happen is it'll be denied and end up being back on the calendar. So that might be some good advice to pass along, to make sure that, you know, you can get voicemail, that you're checking your email, that type of thing.
Courtney, I think it's Courtney, name's cut off a little bit, had a comment about some of that as well. It looks like they're in Dakota County, which is one of the counties we don't actually have covered today. One of the like 3 counties that isn't covered by all y'all's groups. But they were saying first off that Dakota County offers resources like 360 communities that attend the hearings as well to kind of help with that and to request expungements through that process. But then they're also saying with a lot of the eviction cases, there's still judgments entered where a tenant has an application. It's just usually to stay the case pending the application. So telling clients to request an expungement, because even if the rent assistance is approved, there would still be an eviction on the record in the future. I know that's one of the things that we've been seeing a bit of throughout a lot of calls that we get, because we get calls from across the state, is that even if someone files an eviction for non-payment, but the tenant has a rent help application, different courts are doing different things with those cases. So some of them are, my understanding is some courts are staying them, some courts are just making them confidential, some courts are doing just nothing with them and putting the initial hearing date out farther. Like, what's happening in your areas with those types of cases? Free for all.
I guess I can start. What we've been trying to do as much as possible is to, in our agreements, is to have them marked confidential immediately, and then have it stayed, and then have a built-in almost automatic expungement that if the case is not taken off the the calendar or not placed back on it, that it's administratively reviewed and dismissed and expunged.
We have different judges doing different things, but what I'm seeing most consistently is they are continuing out hearings to see what happens while it's pending, basically. And then if it's dismissed before the hearing or at the hearing, the landlord says they've been paid, then they'll dismiss and expunge it at that hearing. Or if the landlord gets paid before then, they can tell the court that they've been paid and it'll be dismissed and expunged. But most of the time, the courts are setting it for continuing it out, setting it for a hearing in like 30 days or 60 days or whatever.
What Katie said.
Okay.
Well, I've been able to dismiss 1 or 2 sometimes. Just I make a rule with 12 motion to dismiss, and they'll just dismiss it based on the fact that they applied for rent help. But I think a lot of the time they just continue the matter. But I'll usually go for the dismissal anyway.
Yeah, why not?
Yeah, and just quickly in Hennepin, similar things. For a while, it was pretty standardized. It was every case with a pending rent help application. If the application had been submitted before the case was filed, we would get it dismissed. If it was submitted after the case was filed, all those cases were stayed and made confidential until June of 2022, unless someone did something sooner, brought it back to the court's attention and got a new hearing. Just recently, a couple of the members of the landlords bar have decided to fight the confidentiality portion of those orders. And so if there's an objection, we need to, hit the elements of the Star Tribune case and try to show why it's important for this particular person to have their case made confidential. It seems sort of obvious to anybody who does any kind of housing work why their case needs to be confidential, but we've now had to lay that out in some cases or show why that's the case.
Thank you all. All right. I'm going to move on to some of the pre-submitted questions that we had from folks. It looks like, so some of these are related tangentially to just the work that y'all are doing. Some of them are just more related to just general advice. So for example, Jennifer, who's a prospective landlord, wants to know their prospective landlord in Minneapolis and wants to know how they can be one of the good guys. I would change that slightly and rephrase it to be, when you were working on cases, since all of you are from the tenant side of things, what landlord actions or inactions do you most often see that lead to kind of strained or frayed landlord-tenant relations that end up leading to evictions?
I will start. I think a couple things. I think it's really important that landlords are educated on what the law actually is. We have a lot of landlords out here who only rent like 1 or 2 properties, and they just grabbed a random lease off the internet, and it's not actually all legal. And so then they'll try and enforce the lease, and we're like, no. So I think one of the biggest things is knowing what is actually legal and what is illegal. So I think that's a really important thing to educate yourself about. The other thing is just communicating. We see so many times where the relationship between the landlord and tenant is so bad that they just can't communicate. And so they end up in court, either the tenant's suing them because, they're violating their privacy, or there's, repair issues that aren't being made, or the landlord's filing an eviction because the tenant's annoying them or whatever. So I think just communicating with the tenants and trying not to take, not paying rent or something too personally. I think that can solve so many evictions. If you're able to communicate with the tenant and say, hey, you owe rent, I don't want to file an eviction, but we either need to get a repayment agreement or move out agreement. Otherwise I will. I mean, that could solve so many problems. So those are 2 of the biggest things that I think are really important.
Thank you, Katie. Sorry, I'm choking on my green tea. Did anyone else?
Yeah, no, I just had one other quick thing on that. And I know, Rachel, you refocused the question on landlord-tenant relationship, and Katie hit a lot of the great points on that. I'll just say too, that for a prospective landlord out there is to think about their admissions policies too. And right now, particularly, we are in the metro area, planning on an influence or an influx of refugees from Afghanistan who will be looking for housing. And that's one example, but there are a lot of groups out there, folks who may not have traditional credit that they've built up or other things, but they are good tenants. They are looking for homes. We have this razor thin housing market that is exacerbating a lot of racial inequality in our community. And so a good landlord is one who not just abides by Minneapolis's tenant screening ordinance, but it is a good landlord is also someone who cares deeply about that and realizes that as a housing provider, you are a person who has access to one of the fundamental things that a family needs in order to survive. So it's a great thing that you're doing it, and take it seriously and do what you can to get people access to housing.
I would add, if your landlord, consider taking Section 8. There's a lot of landlords that won't. It's a great program. If you're worried about getting your rent, that's a great way of making sure you're at least getting a portion of your rent. I think there's a lot of landlords out there that are maybe afraid of a federal program, but look into it, learn about it, and I wish more landlords would take it.
That actually transitions us really nicely into a different question that we had from Joanne, who's a service provider, who just asked what in general landlords view as a good potential applicant, or what items would be a barrier for applicants. So I know some of the things that we talk about at Homeline, but from your perspectives across the state, what are some of the good things and what are some of the barriers that applicants may have?
Well, certainly their history, their rental history. And then, like I said before, landlords, it's a business transaction. They generally want to get paid. And so it's kind of a risk assessment on their part. It never hurts if you meet in person to be presentable and make them smile a little. I don't know. But again, there's not much churn up here in the rural area. It's really hard for people who are being asked to leave their housing to find new housing. Really hard. And So whatever it takes, I guess.
I know in general, when folks are doing application screenings, the big ones are rental history, credit, and your criminal background. Those are kind of the three big programs that we see. And so what we also are aware of, and this is probably more prevalent out in greater Minnesota than necessarily in the Twin Cities area, is that if you are able to actually meet your potential landlord face to face and you're not dealing with a giant property management company, then it's more often you can kind of have a discussion about what any potential negative issues on your background that may crop up, what happened, or have reasons why those are not going to be barriers going forward with this particular housing situation. So,
and related to that too is look into criminal expungements. The Minnesota Attorney General is working on, there's only certain crimes you can expunge, but that's beneficial for people beyond housing.
absolutely. All right, thank you. Okay, let's go with this one's kind of a vague one. I apologize, but I do think that especially legal aid groups across the country state, sorry, we're just a state, we aren't our own country. Might feel like it sometimes, but Jessica is wondering about, she just said VAWA in low income housing tax credit properties. I'm not 100% certain what that question is exactly, but I assume it applies.
Yeah, no, it absolutely does. I mean, what that question might be getting at is the right to an emergency transfer. And so this has been an important element that, unfortunately, I think too many tax credit landlords do not understand that they do have an obligation to allow a person to make an emergency transfer if they needed to. And so this, for folks who don't know, the Violence Against Women Act contains a lot of important protections. One of them is that you can't be evicted because you are the survivor of violence, domestic violence or sexual assault. And you'd think, well, that can't happen too often, but surprisingly it does. We have a lot of cases with domestic violence elements to them, and we use the Violence Against Women Act along with state protections for domestic violence survivors quite a bit in our eviction cases defense. On top of that, if you need to move on an emergency basis to escape an abusive relationship, you can insist that you get an emergency transfer. And a lot of tax credit providers, tax credit landlords have a lot of properties, so some people say, well, we just have this one building. And I realize that is often the case for some of the greater Minnesota folks out there, is that the same landlord may not own a lot of different buildings. Although, as I understand it, even out there, the business is getting consolidated in some of our Wilmer and in Alexandria or in St. Cloud service areas. But certainly down here, a lot of tax credit landlords have, if not hundreds, at least dozens of units, multiple buildings all across the metro area, sometimes in other metro areas, and they are required to not only allow a transfer if a person needs it and certifies it properly under the Violence Against Women Act, but they need to make sure it happens on a timely basis. I mean, we are talking about lives here and people's safety. And so it is important that message get out there. So I know I'm reading a lot into a vague question, but it hit a sore spot for me. So I'm glad someone raised it.
Oh, thank you. Actually, that also helps out with Katie had a similar question about eviction proceeding protections for victims of domestic violence and sexual assault. So thank you for going into that, Luke.
And I would just add to that, domestic violence, at least in our area, has been on an uptick since COVID, I think, with people staying home and all those stay-at-home orders. So this has become a bigger issue, and it's become real for a lot of people. So thank you for going into that, Luke. That's important.
Absolutely. Okay. To swap slightly, we're going to go with another service provider. Julia has a series of questions, some of which I think you've touched on a little bit, but some of them are a little bit more specific. So Julia is curious if there has been an uptick in evictions for reasons other than non-payment, such as are landlords using lease violations as an excuse to evict tenants for non-payment. So sometimes we call that a pretext case. I see smiles from lots of people.
I think that was more prevalent in the past. It certainly was happening. Landlords are very inventive with their pretexts. Not as much anymore from my experience. It's still there. It always will be. But they were creative for a while there, but now it's not as much.
Yeah, we saw with the actual moratorium when there were those, very limited reasons that you could evict people, we saw a lot of, well, they significantly damage property because there's, a broken, faucet, and that's significant damage of property. We saw a lot of those of trying to get creative. I don't think we've seen as many of those. I mean, I've just seen a lot more evictions for non-payment because at this point, I think people have either applied for rent help or they don't know about it. And so we've seen a lot more just straight evictions for non-payment. But during the moratorium, we saw a lot of kind of creative evictions, I would say.
Yeah.
Dogs are much better behaved these days, so.
Yeah, I will say when we were, as we've been going through the eviction cases, a lot of suddenly pets that, are unauthorized somehow that may not have been before. So that has been definitely a uptick that we've seen.
One thing I did notice is people were using, and still are a little bit, HROs, the harassment restraining orders, to try to get rid of tenants. I had one, they're banging their pots and pans and stomping around, listening to loud music. They would try to file an HRO against them to get around having to file an eviction. Things like that came up and still do once in a while.
Absolutely. So another thing that I kind of want to touch on, I know this isn't any of your all's area of expertise necessarily, but it's about rent help. And so that's definitely something that's touching all of our lives in housing land at the moment. So the concern is that rent help MN clearly has not an infinite amount of resources. And so processing the applications that they've got by June 1st of this next year is potentially a concern, although that's becoming less of a concern. But what thoughts have you all had, if any, at this point about what happens come next June or when rent help runs out of money? Commissioner Ho was talking about yesterday with the Senate, had a committee hearing about starting to plan kind of the wrap up of the program. And so these things are at some point in the future coming to an end. So what, if anything, are you anticipating or concerned about? Like what's the future holding right now that you see?
I do think rent help has been moving a lot faster processing applications. So because I was initially concerned when this first started, it felt like it was a very long time, before they got applications processed, but they seem to be moving a lot quicker. So I guess that's less of a concern. I don't really know where it goes from here.
I mean, long before there was COVID, a lot of communities had figured out how to make financial assistance a way to make sure evictions don't happen. Like in New York, every family who showed up for eviction in New York would, and if it was about the rent, they would just get sent down the hall, go into the rental office, and the rent would get paid. And to me, I mean, the answer to this is we need to take the lessons that we've learned from this rent help, situation, and realize that a lot of people were able to save their housing. And when we have, so in Hennepin County, the county itself received approximately 11 million per year in emergency financial assistance that could have been used to help people avoid eviction and save their homes. A lot of that money either didn't get spent, it got rerouted to other things. That was the situation before COVID. What needs to happen is we need to make those systems, we need to learn from how it worked. We need to make those systems actually function. We need to continue to have a real eviction diversion program and learn that from our experiences that you need to meet people at court, pay their rent, allow the evictions to be taken off their record immediately. And the state needs to put more funding into it, certainly, to make sure it happens. But we also just need to improve the bureaucratic inefficiencies that we've all had to deal with through rent help. And, so hopefully those lessons are being learned and will be carried forward by existing financial assistance programs through the county systems. But to more directly answer your question, I think it's a potential additional cliff of filings, that there are certainly some landlords who are holding off on their evictions because they're hoping to collect this rent assistance money. And when they won't be able to do that, we're facing a potential additional wave of cases.
And I can follow up on what Luke was saying. I think if we don't make those changes, we're going to see things reverting to kind of the way they were before, like you mentioned, the county assistance programs. And then most likely also, at least what we've been seeing in our region is landlords are a little slower to file an eviction. I think we're going to see that if there isn't a rent help or some sort of other safety net, we're going to start getting 1 month non-payment of rent cases, where unfortunately, the filing fee is a huge portion of that. And so I think they're going to be quicker to file. They're going to be less willing to wait for funds. They're going to be less willing to maybe work with these agencies that might get them the money if we don't have something to kind of replace what's been going on.
Okay. That kind of brings up a question that I've done as well about some differences in how things are being handled across the state in regards to expungements of evictions. Some of it is that I'm seeing just the expungement hearings are being put off a very long time. Some of them are just being granted, but administratively they're being very slow to actually be removed from the public record. So I guess I'm going to ask a two-part question, if that's all right. How are expungements being handled in your area that you've seen, and do you have any advice on someone who's applying for an expungement at this point to help move their case along?
Well, from my experience, if the case gets dismissed and I ask for an expungement, I think the nature of these centralized calendars, the judges would rather they've been asking that I file a motion, deal with it later. When we used to do them in person, especially if we made a settlement agreement, then we could just do it all in one kind of swoop, and then we submit the documents and that'd be it. But it seems like now the judges, just due to the nature of how many cases they're seeing at a time, they'd rather you just file a motion down the road and we'll deal with it then. That's what I was getting.
Okay.
I think things are probably slightly different in Hennepin. We try to get everything expunged while we have a few minutes of court time, because it's a lot more efficient to get it expunged at the time of the first appearance or when the settlement goes on the record, or than trying to do it later through the motion process. And as far as the motions themselves go, and I should have done this earlier, one of our great partners in Hennepin is the Volunteer Lawyers Network, and right now we route all expungement motions to them, and they do a great job with them. And And so they know more about the current delay. I think it's in like the 2 to 3 month range. The processing of expungement motions has gotten a lot better in Hennepin because they're not conducting hearings on most of them, which, you know, it seems maybe odd, but it works out in our client's favor most of the time, because unless the plaintiff, the landlord, or the landlord's attorney files an objection, there won't be a hearing. The case will just get reviewed administratively, and the grant rate of expungement motions is in the 90+% range. So by and large, a person files a motion, and a couple months later, it just pops off their record in the bulk of cases, which has really improved the efficiency of the whole process. And so it's not as backed up as it used to be, but it's not as efficient as maybe it could be. And it still, we know it's far better to get it done while we have the case in our hands whenever possible.
We, I guess as far as our expungements, we try to get them in all the cases and try as much as we can to make them pursuant to an agreement. I guess pre-pandemic, on move-out agreements, we would always try to work that into the agreement, that if they move out by a certain date, and if you're working with pro se landlords, usually you can sell that or tell a landlord, you know, the advantages to that is it provides an incentive to be out by a certain date, and so they don't have to get the writ and go through that process. And so when we do the motions, I think we do those occasion, and kind of varies, you know, for the judges, but I think advice for someone going into an expungement is I would think a court would be more inclined about the impact on your ability to find housing and those sympathetic factors, as opposed to, you know, re-litigating, you know, why the rent wasn't paid or whatever the issue might be, or trying to fight about the whole thing. Maybe give a personalized impact on how it's affecting you.
Okay. All right, fantastic. Thank you so much for that. We have a question that came up in the Q&A, and I will admit that this is outside of my area of expertise. If any of you have any notion on the answer to this, please feel free to pop in. But Vanessa, who I believe is a service provider, is a client that has a contract for deed that was canceled by the homeowner, and the homeowner doesn't want to rent to the family anymore, and they just got served with an eviction. The contracts for deeds are just outside of Homeline's kind of area of help, and I don't know if any of you handle any of those or want to take a stab at this, but.
I mean, contracts for deeds can be canceled. There are specific things that have to happen, though. So I guess I would advise them to try and talk to an attorney to see if they have any defenses and make sure the cancellation was proper. But if it was canceled and the landlord doesn't want to rent to them anymore, I mean, as long as it was done properly, I don't know if there's a lot you can do. That would be my thought, but someone else can jump in if they have other thoughts.
I thought the same thing, Katie, is that it's kind of fact specific, but there is a requirement of notice and going through the proper channels. And so they might want to check and make sure that has been done, because they do have the right to redeem, and, you know, you can't just come up and cancel it. There's procedural protections. So without knowing the facts, don't know if there are any, but that would.
Well, and just Rachel, I heard the question as being on behalf of a tenant whose landlord was in a property where the contract was canceled.
Oh, okay. That was a different spin than what I've got.
Oh, well, so there are also special protections for tenants in that situation. So yes, I mean, both Brian and Katie are right on as far as if you're the homeowner whose contract is canceled, there are a series of protections. If you're a tenant in a property whose landlord had their contract for deed canceled, there's a special statute that directly applies, and it was passed back in the height of the foreclosure crisis but there is a provision that directly addresses contract for deed cancellation. And so effectively a tenant is entitled to either live out their lease if they have a current lease of a term lease that goes for a certain period of time, and pay rent, or at a minimum, they're entitled to at least a full 2 months of notice before they can be evicted post cancellation of a contract for deed. So that 2-month notice period, it's slightly lower than what a person in a mortgaged property gets, for reasons I don't, fully understand, but that's what the law says. So.
Okay.
It's 504B 151, right? Is that right?
I think it's 2851B, right?
Okay.
I'm not like some other legal aiders who can like rattle off the exact statute.
I applaud you on that even. Well done. So it sounds like this one is pretty fact specific. So in general, it's probably a good idea to see if you can, the tenant can call whoever is in their area to get some more specific advice for their situation. Okay.
I have a question well, maybe not a question, but Heather sent something in via the Q&A about Wings of Newport, and I'll just share. I don't know if that's in anybody's service area here, but I'll just share in the chat about Wings of Newport. It's a complex in Newport, Minnesota, where the landlord has given notice to vacate to a large group of disabled seniors at the property, and was able to do that after the phase out law change in October. And it's a result of it's supposed to be some type of assisted living license at the property, which changed, the requirements for that changed, and so they're not able to provide some of those services anymore. And Homeline's heard from a lot of tenants at that property. So I'll just put in the chat the link to a Star Tribune article about that. And I don't know if anybody has any comments, feel free to add them, but Heather will get in touch with you directly too on that.
Yeah, I mean, I don't have a direct knowledge about it. I just heard about it or read that, and I'll just say one thing is, it seems like some of these buildings, like if the reaction to a change in like rent or in policies about what kinds of subsidies that they'll accept, like there's this concept that they won't accept housing supports anymore or whatever. And I don't know enough about this specific case, but I'll just remind everyone that, that there are anti-discrimination provisions in state law, federal law, local laws, and those anti-discrimination provisions include receipt of public assistance. So if you have a building who may or may not be this one, who's deciding on a categorical basis not to allow people who receive a certain subsidy to live there, that could form the basis of a discrimination case. So.
Thanks, Luke.
Okay.
Well, I don't think we have nothing in the queue. Maybe you saw something, Rachel, but we've got like 10 minutes left. Again, I want to thank everybody on our panel's time and expertise in sharing about their experiences right now in the courts. It's been very interesting and helpful for us, just personally, I think, and I assume for participants. If anybody who's joining us has a question, feel free to submit it fairly soon here. Did you have another one, Rachel?
There was one more that was submitted ahead of time that was specifically about notices to vacate at a mobile home park on a month-to-month lease. And so Melissa, I can just take that one quick. Basically, there are very specific notice requirements for mobile home parks, 327 point something. I think I'm not quite as good as Luke as pulling up my statute numbers off the top of my head. So that notice potentially could be given. Again, it's a very specific, fact-specific question for the given situation. So you probably want to talk to a lawyer about your specific situation, but in general, notice for lease termination needs to follow the appropriate requirements under the statute.
I can just add something to
I
to
suppose,
that,
Brian,
Rachel.
you're dealing a lot with mobile home park notices right now.
We are, and one of the, I think the big distinction or the fact we would need to give a kind of a more thorough answer would be whether or not the person owns that mobile home. We occasionally see someone where they don't own the mobile home and they just are renting. And if that's the case, then just standard landlord tenant, they just happen to be renting a unit that's also a mobile home. But with a person that owns their home, additional protections that come in that you mentioned, the 327 C.09, which is the termination, and you have to have cause for that. You can't just say, I no longer want to rent to you, or I want to remodel. They own that home and they have those additional rights. So that's probably the key. The information that's needed for that particular question is it a homeowner or is it someone who's just renting?
Thank you, Brian.
So I have a question that I guess maybe Luke and others got to a little bit in terms of in the context of with Minneapolis and St. Louis Park having pre-eviction notice requirements. But did you all see an impact? There was, of course, a 15-day notice requirement as part of the phase-out law that was in effect from July until mid-October that required a notice and some information from the landlord to the tenant about rent help MN. I mean, some of you are mentioning people showing up to court without any knowledge about rent help MN. It seems to me that a notice requirement that gives people information about what resources are available, it seems like pretty much common sense. Anything that you can comment on in regards to that, in particular cases that you saw in that time period from July to mid-October? Was that notice something that was useful to clients and helpful if things got to court?
I think it was super helpful. We had people calling us ahead of time. I think a lot of evictions didn't go forward because people got those notices and did apply for rent help or did call us. So I think they were super helpful, but we did have some tenants who did get notices and just didn't read them. And so they got notices but still didn't know about rent help. So, I mean, if you get a notice, read it would be my advice. But I would love, I'm a little jealous of Minneapolis's law because I think that can help save save landlords money in filing evictions and save tenants having an eviction on their record if they get that notice ahead of time. So.
It's true. It makes sense if folks want to get paid. It's having resources are a more likely way to get paid than just starting over with a new tenant and making someone else having to go through trying to find new housing.
Yeah, and Eric, for future legislative efforts, I think there are a lot of great examples, and I also think. So from the tenant's perspective, great examples of people who got the information on a timely basis. But then on the flip side, hopefully there are some landlords out there who realize, wow, that really wasn't the end of the world to have to send, a single piece of paper before taking someone to court. It really wasn't that huge of a burden. Hopefully that's in these petri dishes of the state law for a short period of time in Minneapolis and St. Louis Park. Maybe I'll realize like, wow, that really wasn't that hard. And so we can keep doing it.
Yeah, I agree with Luke and Katie. One of the things we'd been working on before COVID was trying to put on the summons for evictions, just put legal aids information for people in our area, just so they could get in touch with us beforehand, just because a lot of people don't know that option is available.
Interesting. Yeah, Courtney points out, and Peter actually kind of echoes that, is that there are a lot of tenants who just don't necessarily understand their notice or their summons, whether it's just for language barriers or whether it's because there's a lot of information just plastered onto one page. So yeah, the any considerations actually, that's a good question. Your organizations have the ability to assist with multiple languages.
Yes, we can do applications in multiple languages. We can, you know, help people represent people in court. Yes. So if people are having issues with the language barrier, still encourage them to call our office because we can get an interpreter.
We don't get that too much in Brainerd, but it does, we do have the ability.
And yes, smirls, you know, has that with our own staff or language line, or yeah, they should definitely give us a call.
Thanks. I was partially queuing up that last question to just note that in January our webinar will be we'll have Senator Carrie Dietzick and Representative Kelly Van-Her on the webinar to talk about some tenant landlord policies, one of which is around pre-eviction notice that has been circulating and made it through a lot of committees last year and has been on the legislative agenda of Minnesota Housing and the governor's administration. So we'll be learning more about that on January 12th, and I'll put the link in the chat because I think we got one other question that came in.
Yeah, it looks like this anonymous question about how notices to vacate may impact retaliation arguments, specifically for tenants facing just a notice to vacate for no reason at this point.
Well, of course, we could all have a whole seminar on that, but it is fascinating. And I mean, in a short answer for people is to just know that we don't have just cause eviction, unfortunately, in the state, unless you live in a tax credit property or a subsidized property. So, you know, I mean, in the meantime, though, the landlord doesn't have to give you the reason why they're telling you to get out, but you should trust your own instincts. And if it feels like it's because you're being retaliated against, then call a legal aid lawyer and we'll walk you through what your rights are. And absolutely you can have, and real defenses too. I mean, the law here says that landlords have to prove they're not discriminating against you under certain circumstances. So it's just a lot of folks are getting these notices now because the law opened the door to them. So there's a flood of notices to quit, notices of non-renewal going out there. And you should at least consult, I think, with someone. I know Homeline, you know, probably fields a ton of those calls too, and can give good advice to people about like what the law says, and send them on in. So absolutely, don't just take their word for it. I guess at least know your rights before you make decisions about whether to move or not.
And clearly we're coming to the very last minute of the scheduled panel show because we're getting questions again. If a tenant is giving a address that is not their most recent address on an application, this anonymous person is asking if there's any defense against that. I mean, I guess I would assume if there's an eviction notice or notice to vacate for giving false information. I think, you know, it is now 3 o'clock according to my clock. So it's a little bit of a tough question to answer within 30 seconds. So maybe something that there is some statutes in Chapter 504B that talk about applications and falsifying information and what needs to be included, what doesn't need to be included, that sort of thing. It does, most of the application requirements are left up to the landlord across the state to determine what they apply for or what they look through. So it may or may not be a falsifying question. So I think my recollection is at this point, only Minneapolis has some structure as to what a landlord can and cannot ask about or look into for a background screening for tenants. Please, anyone from around the state, correct me if I'm wrong. So that's my understanding of that whole process in a very quick nutshell.
It depends, right?
It depends. Of course, it depends. The very lawyery say. So I think we're gonna at this point wrap that up.
We are, yes.
So thank
uh,
you from me.
Thanks, Rachel, for facilitating, and thanks, Chris, Brian, Luke, and Katie. Really appreciate you being a part of this today, and sharing your expertise. And so maybe we'll at some later point check in again to see. Hopefully things are going well or better as the Rent Help Amend program winds down, and maybe something else replaces it. But appreciate your time today. So thank you.
Thank you.
Thanks.
Keep
Thanks.
fighting the good fight, everyone.
You too.
And we'll have a recording of today's session up on our website for you to share too. So thanks again for joining us, and talk to you later. Bye-bye.
Have a good one. Bye.